You know that face, right? When you've got him. You got him. And you're going in for the kill. And then you look. You round the corner. And you say, oh, shit. Because there's a gun barrel right in your face, right? Because you thought you had him. But you don't. That happened today. At least in my humble opinion. And I think you guys know what I'm talking about. So let's dig into this. And the other day, I bought this special bottle of whiskey. This is a 12-year Lagavulin. 16 is the common one, but they decided to make these limited edition 12-year versions, and they're cask strength. So they're a little terrible at this, a little heavier on the alcohol. Should be more like a kick to the face, and I have been just waiting for something stupid to happen. And it has. Ooh. So let's start talking about this. And this is going to be a little more technical, and I'm not going to look at the lawsuit document itself at all. Instead, we're going to look at some of the other filings. So if you... hold on. I've never tried this, so give me a second. Whew. That kicks a little bit harder than the 16. It's rather delicious. I'm a fan. That's good stuff. Sorry to drag you through that, but you know, I have to enjoy things and you have to deal with it. So if you are not aware, today we have some documents dropping in the LoLsuit, as it has been dubbed. So before anybody is super confused, if you're looking at the document list, which I think I'll provide a link to in the description of this video, because if you haven't seen the document list, as you file documents in New York, they have this cool online list where you can actually just pull them up and look at them. Very convenient. Minnesota should take notes, because for some reason we have to go into a courthouse to pull these up because someone's an idiot. But in New York, you can just pull them up right online. So, the documents that have appeared, there are 6 of them. 7? 6, 7? 1, 2, 3, 4, 5, 6, 7 of them. And most of them are actually just repeats of previous documents. But the important ones are first this judgment, clerk default, proposed. Okay, so this is a proposed order for a default judgment. A lot of people are kind of confused because it uses the language and it looks kind of like a court order that says that Asterios has lost the lawsuit. That's not the case. If you're not familiar with the U.S. legal process, you have to file, typically, a proposed order. Makes the judge's job easier, and more. It makes the judge more likely to do what you want if you write down what you want and then just leave a space for him to sign it. And judges will sometimes follow this and sometimes not. In this case, there's no way a judge would follow this, even if there was a default judgment against Asterios. And spoiler alert, probably not. But even if there were a default judgment against Asterios, the order is not something the court can do. The court can't enforce an unlawful or unconstitutional order. And one of the things that they request here is that Asterios defendant... Okay, sorry. General Business Law, Section 349, 350, and orders and permanently enjoins Kokonos from featuring, distributing, or using either of the plaintiff's name, including George Uzunian or Maddox, or any similar derivation thereto, photograph, portrait, image, and or likeness in any way and for any matter whatsoever and in any form or format whatsoever, and that the current use by defendant Asterios Kokkinos be immediately taken down from any and all websites and social media, specifically and including Kokkinos' YouTube, Patreon, Facebook, Twitter, and Reddit accounts, and that defendant Kokkinos be enjoined from any further use of said accounts, and that said accounts be permanently removed and taken down from said such social media websites immediately and forever. And it is further order and adjudged that Kokkinos be ordered to retract any and all statements published by him relative to plaintiffs and issue a comprehensive public apology towards plaintiffs that is filed with the court, and remove and destroy said statements and photographs relative to plaintiffs. Apostrophe, God, come on! From any and all websites, social media platforms, and other advertisements or promotions that exist. This is like the most unconstitutional order you can possibly have, right? You can never say or publish or print Maddox or George Uzunian for any reason, in any way, for any matter whatsoever. I mean, come on, Maddox. And Maddox is a Landau. You can't be that stupid. The judge can't sign this. He can't sign it. Why would you file this? Probably because you put an apostrophe after plaintiffs again. Anyway, so let's take a step back, shall we? So that's the proposed order, and proposed orders don't mean anything because the judge hasn't signed it. The signature line is blank. It's listed as pending on the New York Supreme Court website. So that's not a thing that has happened. Asterios has not been fined $20 million plus $25,000 in legal fees. Let's take just a moment and talk about that. So part of what they're asking for in this default judgment is the full $20 million, jointly and severally. They mean with other defendants. So if you're jointly and severally liable, I mean, they're asking for default judgment against all of the defendants with Kokkinos owing something. Okay, I guess. But they're all liable for it. But I guess it's severable because any one of them could pay at any time. I don't know. I can't trust this attorney actually doing anything correctly. So we'll see. Along with $340 in costs and disbursements and attorney fees in the sum of $25,000. Now, I don't know what Kevin Landau charges, but I'm going to guess Kevin Landau charges about $250 an hour, and he is suggesting that he should be awarded $25,000. So he has put in 100 hours of work into this. That's what he's basically saying there. Now, I'm not familiar with how attorneys' fees are done in New York. Don't really feel like researching it. I apologize. It's not that important to how they're done. In Minnesota, you have to account for all of the money you're asking for, right? So if I say that there are $25,000 in fees that are owed to me, I have to show where that $25,000 came in. I have to express my rate, and I have to justify my rate. So if I say I'm worth $250 an hour, I have to justify that by location, by the type of matter it is, by the competitive use in the area, by how long I've been practicing, these types of things, by if this is in my area of expertise or not. All of those things kind of factor in. Now, maybe he's saying he's $500 an hour and a $25,000 reward, so, a 50-hour task. No, this doesn't look like 50 hours, folks. This doesn't look like 100 hours, 50 hours. I don't think that this attorney drafted the original document. Maybe he did. And if he did, that's really sad. I was starting to give him the benefit of the doubt and think that Maddox just did it. But maybe this attorney did it. But it still doesn't look like a 50 to 100-hour job. So anyway, I want to talk about that. I don't believe Maddox has paid $25,000 to this attorney. I don't believe that for a moment, right? It's possible that has happened. But what's likely happened is that the most likely outcome is that this attorney told Maddox he would take it on a contingency fee, And now that it's looking like they're going to win a default judgment, he's asking for a $25,000 fee award to him as opposed to taking a contingency because he knows that Asterios can't pay him $20 million. But if he can get his own award in $25,000, maybe he can file a collection or do a judgment against Asterios for that. I'm not positive. I can't say. What I can say is that if this guy's getting paid $25,000 for this suit, then Maddox should file an ethics violation against Kevin Landau. Maddox, if you're watching and you paid this guy $25,000 and you didn't write that document yourself, actually, no, especially if you wrote the document yourself, and this guy took $25,000 of your money, file an ethics complaint against him because what he's doing is illegal. So, I mean, that's just my opinion. I'm not an expert. Maddox, hire another attorney, don't pay him $25,000, and consult with him whether or not this guy violated ethics rules if he charged you that much. Or maybe you guys are lying to the court. You don't have a history of that, though, so I wouldn't want to accuse you. So anyway, that's the first one. The next document is an affidavit of George Uzu Noodles. Uzu isn't noodles. Uzu's like liquor, right? Uzunian. I'm never going to learn how to say your name right. Let's see. So this is just an affidavit by George saying that he affirms all the stuff involving Kokonos and that this judgment should be made pursuant to civil practice law in New York. What is it? Civil practice laws and rules number 3215, and for the relief requested in our complaint. So briefly, a default judgment. Okay, that's where a complaint is made and filed with the court, and then the other party never responds to it. They have to get the document, like you have to show that they've reasonably been given notice and they've had an opportunity to respond, and they just don't. So then the court can come in and issue a default judgment, and then you can try and collect on a default judgment. And there are various remedies, right? If you get a default judgment and you say, I never got the documents, and you can kind of show some reasons why you never got the documents, then you can defend against it. Or if you did get the documents but service was improper, then you can also defend against the default judgment, and you can have the lawsuit dismissed and the judgment vacated. So those are options. Or maybe it's possible that the attorney filing for default judgment doesn't understand the civil procedure in the state where he's licensed. This sometimes happens, right? Civil procedure is a boring class in law school. A lot of people fall asleep during it. And if you don't do a lot of civil procedure practice yourself, or if you have like a new paralegal who's not very experienced, maybe you miss some steps or you misunderstand some laws. Or like if you practice in two different states, maybe you get them mixed up. I don't know. Could happen, right? So let's see. Let's see what happened, and let's dig into the rules a little bit and see if Mr. Landau, can I call you Kevin? If Kevin knows what he's doing. The next document is another copy of the summons and complaints. I'm not going to even look at that. The fourth document here is actually really interesting. This is the affirmation of counsel. Okay, so I'm gonna breeze through this. It's the affirmation of Kevin Landau, Esquire, in support of default judgment against defendant Asterios Kokonos only. Asterios Kokonos, comma, only. Why do you have a comma there? Like, it's just only. Okay. Kevin A. Landau affirms the following, subject to the penalties for perjury. I'm an attorney admitted to practice law in the state of New York and counsel to plaintiff herein. I have personal knowledge of the matters set forth below, and the exhibits annexed hereto are true copies of the original documents. I submit this affirmation in support of plaintiff's application for the entry of a default judgment against defendants apostrophe Asterios Kokonos. There's just one, and it's not possessive. pursuant to CPLR 3215A. Let's take a pause and look at what CPLR 3215A is. As default in entry, when a defendant has failed to appear, plead, or proceed to trial of an action reached and called for trial, or when the court orders a dismissal for any other neglect to proceed, plaintiff may seek a default judgment against him. If the plaintiff's claim is for a sum certain, a specific amount of money, or for a sum which can be by computation be made certain, application may be made to the clerk within 1 year after the default. They're alleging that the default just happened. So let's keep going. The clerk, upon submission of the requisite proof, shall enter judgment for the amount demanded in the complaint or stated in the notice served pursuant to subdivision B of Rule 305 plus costs and interest. Upon entering a judgment against less than all defendants, the clerk shall also enter an order severing the action as to them. When a plaintiff has failed to proceed to trial of an action reached and called for trial, or when the court orders a dismissal for any other neglect to proceed, the defendant may make an application to the clerk within 1 year after the default, and the clerk, upon submission of the requisite proof, shall enter judgment for costs. Where the case is not one in which the clerk can enter judgment, the plaintiff shall apply to the court for judgment. Okay. So they've applied, as far as I can tell, to the clerk, for judgment. They're going to have to apply, in my opinion, they're going to have to apply to the court for judgment, ultimately. One, this is it's not just a sum certain judgment, right? This is not just a monetary settlement. They're asking for injunctive relief, prohibiting Asterios from speaking, removing his First Amendment right? Let's just have him shut up. Maybe we can have his vocal cords cut or something, something bolted onto his mouth, I guess. The clerk of the court can do that. Not a judge, just a clerk. That's not going to work, right? This is only applicable to a sum certain, and the other parts of it will have to go to a judge for judgment anyway. Bad form, guys. If you would just have asked for the money, and you were right, which is the really crucial part, being correct. If you had done that, then maybe the clerk could do it. But you haven't, so we'll go on. This action was commenced on November 6th, 2017. A true copy of the summons and complaint is annexed hereto as Exhibit 1. Now, the action is commenced in New York when you file a summons and complaint. Commencement of the action doesn't really mean anything until you serve the parties properly and give them a time to respond. So, but that's right. November 6th is when they were filed with the court. Jurisdiction of the subject matter of this action is based on personal jurisdiction. As defendant Kokonos resides in New York, and is employed as a senior copywriter at Weber Shandwick at its office located in New York, New York. Okay. On November 9th, 2017, Lawson Legal Services, New York Process Servers, was engaged to handle service of process for defendant Kokonos. A true copy of the proofs of service for defendant Kokonos is annexed hereto as Exhibit 2. We've already seen or if you look on the document list, service of Asterios is in one of the documents, but, it's also here. And again, in another document, which is fine. This is the, wait a minute. No, that's right. On or about November 14th, 2017, defendant Kokonos sent a tweet from his Twitter page acknowledging service of plaintiff's lawsuit upon him, stating in the pertinent part as follows: "What's got two thumbs and is getting sued by @Maddox rules? This guy." Further, defendant Kokonos asked his followers to, quote, "contribute to the Asterios Kokonos legal defense," end quote. Moreover, defendant Kokonos attached a copy of the summons from plaintiff's complaint to this tweet, annexed hereto as Exhibit 3 is a true copy of this tweet. This is all fine, by the way. Asterios can absolutely do this. Considering that that defendant Kokonos was personally served with the summons and complaint on November 9th, his answer to plaintiff's complaint was due on November 30th, 2017, or on December 9th, 2017 at the latest. This is where we run into problems. Okay, so personal service can happen in a couple ways. And I am going to take the defense attorney approach to this And I'm going to say that in this paragraph, Kevin Landau lied under oath. Which is a pretty damning claim, right? I should be able to back this up, and I'm going to. He will say he did not, and when called out, he will say he made a mistake. I don't think so. I think he's lying to the court to try and get an advantage, which is never a good plan. I mentioned earlier, guys, don't lie to the court, because if you have any attorney paying attention to this thing on the other side, they're going to point it out, and it's going to get ugly when the court starts asking questions. But what is personal service? So, this is covered by CPLR 308. Personal service upon a natural person shall be made by any of the following methods. 1. By delivering the summons within the state to the person to be served. You go up, you hand someone the service, done. They've been served. I mean, there's some nuance to it, right? You hand them the papers, and they're served. If you hand them the papers in an envelope, you got to tell them what's in the envelope. You got to say, this is a summons and complaint. You need to open this and look at it and respond. Then they're served. If you just hand them a closed envelope that's not labeled conspicuously as summons and complaint, they may not, they may not actually be served at that point. And they can say, no, we just never opened the envelope from this random stranger because who cares? I don't open envelopes, so I don't know what that is. But if the person announces it, and this would be a back and forth argument. This doesn't matter because we know that Asterios was not served in this manner because Landau he told us exactly how Asterios was served by actually the summoning, or the service company did. Raymond Hollingsworth works for the service company. So going to that document real quick, the Affidavit of Service for Asterios Kokonos. I'm going to read through this real quick. The undersigned being duly sworn deposes and says, deponent is not a party herein. So yeah, the guy who's serving is not a party to the lawsuit. So Maddox couldn't hand this to Asterios. He has to get someone else to do it. He's over 18 years of age, and that on Thursday, November 9th, 2017 at 11:39 a.m. at 909 3rd Avenue, New York, 10022. Deponent served the within notice of commencement of action of subject to mandatory electronic filing summons and complaint on Asterios Kokonos. But how did he do it? What follows is a series of checkboxes. And you can check individual if you hand the copy to the defendant himself. That's not checked. What is checked is suitable person. They delivered thereat a true copy of each to Joshua Kaufman, a person of suitable age and discretion. Joshua Kaufman, if you don't know, is general counsel for Weber Shandwick, Asterios Kokonos' employer. Sorry to dox you, buddy, although I think by now everybody knows. The next part that's checked is mailing. Deponent also enclosed a copy of same in a post-paid sealed wrapper properly addressed to said defendant at defendant's last known residence, 909 3rd Avenue, New York, 10022. That's interesting, because that's the Weber Shandwick address. And depositing said wrapper in a post office official depository under the exclusive care and custody of the United States Post Office Department with New York State, mailed on November 13th, 2017. This is going to be important. Next one's military service. This doesn't matter for our purposes here. Read it yourself. I don't even care. So they say they did not hand the document to Asterios. So we got to look to the next section. This is subdivision 2 of that CPLR 308. By delivering the summons within the state to a person of suitable age and discretion at the actual place of business, dwelling place, or usual place of abode of the person to be served, and by either mailing the summons to the person to be served at his or her last known residence, or by mailing the summons by first-class mail to the person to be served at his or her actual place of business, in an envelope bearing the legend personal and confidential, and not indicating on the outside thereof, by return address or otherwise, that the communication is from an attorney or concerns an action against the person to be served, such delivery and mailing to be effected within 20 days of each other. Proof of service shall be filed with the clerk of the court designated in the summons within 20 days of either such delivery or mailing, whichever is effected later. Service shall be complete 10 days after such filing. Proof of service shall identify such person of suitable age and discretion and state the date, time, place of service, except in matrimonial actions where service hereunder may be made pursuant to an order, blah, blah, blah. Doesn't matter. This isn't a matrimonial action. Marriage is not happening between Maddox and Asterios. Neither is divorce. So, couple things here. It has to be mailed either to the person's residence or, let's see. Sorry, lost my spot. Yeah, or his or her actual place of business. In an envelope bearing the legend personal and confidential and not indicating on the outside thereof. We don't know what, we know they mailed it to Weber Shandwick because they didn't mail it to, unless Asterios lives at Weber Shandwick. We know that they did not mail it to Asterios' house. And I guess it's possible that he lives in the building at 909 3rd Avenue, but they don't include his residence number, so I'm assuming they mailed it to Weber Shandwick. But we have no idea what the state of the envelope is, so we're not actually sure at this point if that was proper or not. We don't know. We do know they went ahead and mailed it as they were supposed to. So if we assume that they did the envelope properly because they hired a professional service firm, then yeah, within, let's see, they had to mail it within 20 days of delivering it. So they mailed it on the 13th, dropped it off on the 9th. They're within 20 days. That's great. But here's the important part. Service shall be, proof of service shall be filed with the clerk of the court designated in the summons within 20 days of either such delivery or mailing. They filed it on the 29th, so they're within the 20 days, whichever is affected later. So they technically had until the 3rd of December. They chose to file it on the 29th. That's fine. Service shall be complete 10 days after such filing. Service shall be complete 10 days after such filing. Proof of service shall identify. That doesn't matter. When you say that he was personally served on November 9th, his answer was due on November 30th, or on December 9th at the latest, you're not correct. Because service is not complete until 10 days after you filed on the 29th. That's December 9th. That means that he has 30 days from December 9th to respond. January 8th, I think, if my math is right. I'm a lawyer, I don't do math. Apologize. January 8th, or January 9th maybe, whichever one it is. I don't know how many days are in anything. In either case, you have made a materially false statement under oath in a writing. You don't even have the excuse of saying, you know what, I got mixed up as I was talking. You have a writing. You have to research this because you have to know this. You're filing default judgment a month ahead of when the answer is due. That's not a good thing. It's not a good thing. He may have been personally served on November 9th, like, sort of, because you delivered it to Kaufman, but he wasn't actually personally served until December 9th, 10 days after you filed it. You lied, buddy. You lied. Or you made, I'm sure as you will say, a grievous error, right? I hope you get slapped down for that one in court. Plaintiff has not received any correspondence from defendant Kokonos because he doesn't have to respond for another, 24 days. Or his counsel relative to the summons and complaint filed against him. Like, you're sued for $20 million. You've got people trying to raise money to help you hire an attorney. Presumably, Asterios has an attorney because he's kind of gone incognito and he's not saying much. We don't know who his attorney is. I'm guessing the attorney knows how to count. I'm not sure at this point that Landau and Maddox do, because both of them have filed affidavits that this default judgment should be entered, and both of them are wrong. So that's funny. Good job, guys. I'm going to go through this in an easier way, though, in just a minute, because what I'm doing right now is I'm digging into the laws, and again, I have to point out, I'm not a New York lawyer. I'm not familiar with this stuff. I just happened to be researching it the night prior to this being filed, and then this happened. And so I was looking at it, and man, it sure doesn't look good for you guys. So let's finish up this document. Yeah, plaintiff is not... Therefore, as of November 30th, 2017. Now, this is an important point here. As of November 30th, 2017, defendant Kokonos was in default pursuant to CPLR 3215 for his failure to plead, answer, or otherwise defend this action as fully appeared from the court file herein, from the attached affidavit and exhibits annexed hereto. 3215. 3215. Oh, yeah, it doesn't say the time on 3215. But it does in what? 3206A. Here we go. 3304. Bear with me here. Let's see. Or was it... Okay. Sorry. I got a little mixed up on my paperwork here. Because again, I'm not a New York lawyer. I had to figure this out. Kevin Landau is a New York lawyer. Should know this. Should have someone on his staff who knows it if he doesn't. 320. Rule 320A. Requirement of appearance. The defendant appears by serving an answer or a notice of appearance or by making a motion which has the effect of extending the time to answer. An appearance shall be made within 20 days after service of the summons, except that if that summons was served on a defendant by delivering it to an official of the state authorized to receive service in his behalf, or if it was served pursuant to Section 303 or Subdivision 2345 of Section 308. If you remember, that's how Asterios was served. Section 2 of 308. If that happens, the appearance shall be made within 30 days after service is complete. 3208. Service shall be complete 10 days after such filing. If we just read the law, Rule 320A requires Asterios to appear 30 days after the filing on November 29th. Or no, after 30 days after 10 days after November 29th. So 40 days. 40 days. January 8th, I believe. So when you say, again, that... and this is funny because he says as of November 30th. The only way November 30th is the date, is if he walked up and handed the document, the process server, to Asterios. And the reason I say that he's lying, and again, I'm taking this from the defense attorney perspective because the plaintiff's attorney is writing this in a document and swearing it under oath. He has a responsibility to make sure his stuff is accurate, that his statements are true and legal. He's saying, by saying that as of November 30th, Asterios is in default, he's literally saying we walked up and handed it to him, even though he filed the document that says they didn't do that. That's a lie. Under oath to the court. And it's not the first one, and these may be just careless mistakes, but that's not how Asterios' attorney should treat this. He should absolutely... I shouldn't say he should do this, because I'm not giving legal advice to Asterios' attorney. If I were Asterios' attorney, I would be all over this guy for lying about my client under oath in a writing that he had time to research and prepare and double check. As such, the time for defendant Kokonos to appear or file an answer has passed, and Kokonos has not filed an answer, and therefore he is plainly in default for his failure to answer plaintiff's complaint under CPLR 3215. Accordingly, based on the foregoing and the documents annexed thereto, plaintiff respectfully requests that the court grant leave and enter judgment by default against defendant Kokonos for the relief demanded of plaintiff's complaint and in the proposed order attached hereto pursuant CPLR 3215, signed by Kevin Landau. So, let's, yeah. No. No. Again, this is a problem, right? Like, this is you not knowing the law. And now, I will say that the New York Rules of Civil Procedure are very cumbersome. I don't like the way they're laid out. That's why it actually was kind of dealing with this yesterday. Like, there's a lot of stuff to go through, and it's kind of uncomfortable. But, let me pull up a website, and let's see here. Because there's this interesting thing that courts do, right, for what's called a pro se litigant, someone who's working on their own, who doesn't have an attorney, right? The court likes to help them out as best they can. So if you go ahead and go to the NewYorkCourts.gov webpage, there's actually a thing on how to start a case in New York City Civil Court. This is beautiful. And I'll just, let's see. Let's see. Sorry, serving the summons. So, after obtaining the summons and complaint from the clerk, the litigant must then have the summons and complaint served on the other party. Cool. Tells you how. And then here we go. Personal delivery, copy of the summons and complaint may be served by giving it to the defendant in his or her hand. Substituted delivery, copy of the summons and complaint may be left with a person other than the defendant of suitable age and discretion at the defendant's residence or place of business. Copy of the summons and complaint must be mailed to the defendant in an envelope marked personal and confidential within 20 days of the service on the substituted person. The envelope may not indicate that it is from an attorney or that it concerns an action against the defendant. That's great. Then we've got Affidavit of Service. So after the copy of the summons has been served, the person who served it shall fill out an Affidavit of Service. You may download the Affidavit of Service form now, or you may obtain it from the court clerk, blah, blah, blah. Section 4. The defendant normally has 20 days, exclusive of the day he or she is served, to appear in court and file an answer. However, if the summons is served outside the city of New York, or by other than personal in-hand delivery, the defendant has 30 days to answer from the filing of the proof of service. When the summons and complaint were served by a substituted or conspicuous service, the defendant's time to answer does not begin to run until the Affidavit of Service is filed in the court. This is on the self-help page for New York courts. The self-help page for New York courts. So, that's interesting. Yeah. The other thing that's interesting, and this I have to look up and may have to do another video on, because I'm just reading this now. This hasn't been something that was on my radar. But in the beginning of this part, it says, in general, the person suing is the plaintiff. More than one person may join the suit as co-plaintiffs. The person being sued is called the defendant. You may sue more than one person in a single summons, but the cause of action must be related. The jurisdictional limit for each cause of action in the civil court is $25,000. That's New York City Civil Court, so that might not apply. Let's see if there is a New York County Court rules. New York State Courts. These are the same. Okay. This is just good stuff. I think this is just the full court rules. This doesn't really matter. My point in all this is that this is findable. This is findable by a normal person who is not represented by an attorney, just by going to the New York court's website. And gosh, I just I don't know, man. This is a pretty bad mistake, in my opinion. Now, what's the ramifications of this? Obviously, the judge should... the clerk should go ahead and just shut this down immediately, right? They should shut this down, no problem, because service was not complete until November 29th when it was filed. Actually, until 10 days after November 29th. So, yeah, that's the first thing that should happen here. What happens? The motion for default should be thrown out immediately. I would suggest that the court may look at strongly warning the plaintiff and the plaintiff's attorney against stuff like this, because what they're doing is demonstrating, one, that they don't know the law. In Maddox, you should consider that your attorney has now demonstrated a lack of understanding of the law. He's not properly representing you. And he may, I don't know what your fee arrangement is with him, right? But he may have charged you for filing this motion, this frivolous motion without a basis in law, which is obviously against the rules to anyone looking into them. I want to go... You know, so there's a potential other problem here. There's a potential other problem, and that's when, let's see, where is it? So this is an interesting possibility that I found in the commentary on this rule, right? So the way this works is the rules are issued, and then there's annotated rules, and the annotated rules have all sorts of scenarios that could be helpful in figuring out tough situations. So the service upon Asterios may have been completely improper. Delivery of process. This is okay. So this is one of the annotations to the Rule 308. Delivery of process to a co-defendant who resides or works at the same address as that of the defendant will not suffice under CPLR 308-2 when the co-defendant's interests in the litigation are adverse to those of the defendant. Such was the case in Martinez versus McSqueeney. Unpublished opinion reported at this. It doesn't matter. There, the co-defendant of whom process was served was a tenant who occupied the apartment owned by the defendant landlord. Plaintiff had been injured in the apartment when the window fell on her hand. Court determined that in those circumstances, a co-defendant was not a person reasonably likely to convey notice to the defendant. The standard for the person of suitable age and discretion articulated in City of New York versus Chemical Bank. The co-defendants had conflicting interests as to such matters as who bore responsibility for the repair of the window, whether the tenant or landlord or both had notice of the condition of the window, and what might be the proper apportionment of liability. This is really interesting specifically to Asterios, Kaufman, and Shandwick, okay? Because Kaufman and Shandwick's interests are not necessarily in line with Asterios. There may be a conflict. In fact, I would argue that there is a conflict. And I think that that's the reason that Shandwick probably isn't representing Asterios, is because there's a potential conflict of interest. Let me talk about that. Shandwick is accused by Maddox of being complicit in Asterios' horribly unlawful behavior, according to the complaint, right? If we take the complaint at face value, and we say that all of the allegations are true and that they're illegal, and I know no one is leaping that far, but if we do, and that's how you have to look at these things, right? You have to look at the affidavit or the complaint as if it is a true statement of fact and law when you're determining conflict. Because if a judge decides it's a true statement of fact and law, then you have to figure, then everybody's screwed. Shandwick's interests are opposed to Kokkinos here, because Shandwick could say, he did not have permission to use our material and equipment. He did not have authorization to do this at work. We have no liability in this matter. We were in the process of investigating this when the lawsuit was filed. Asterios Kokkinos has been evasive in our investigations. We do not affirm this activity. We do not endorse any of this. Their liability could be completely removed by blaming Asterios for everything, saying we have no part in this. This is on him. If he did something illegal, it's his acts, not ours. And anything that he's done involving our stuff was done without authorization, or specifically against our permission. It is possible that Maddox has failed to serve Asterios Kokkinos in this manner, because they served it upon Kaufman, who accepted it. That's fine. And before the like 3 Maddox fans who watched these videos, which is probably just Maddox watching it 3 times under different accounts or something, before you come out and you say, but Asterios tweeted about it, admitting that you have seen the documents incidentally doesn't actually matter. And there's, let me see if I can find this real quick. Sorry, there's a lot of different rules. Let's see. I'm trying to find the specific rule. Let's see. It's delivery and mail, court ordered, location of delivery, fixed mail, court ordered. Okay, this is waiver of service. Oh man, this is really really unfortunate. Oh, is it here? Let's see. Okay, I found it. I apologize for that delay. This is to address the point in the affidavit about the tweet. It doesn't matter. That tweet is irrelevant. Asterios could put out a billboard in front of Maddox's house. I got your documents, dummy, but you did it wrong, right? Like, let's do this. Although the due process standard is simply one of reasonable notice, the Court of Appeals has made it clear that the defendant's fortuitous receipt of the initiatory papers will not suffice to confer jurisdiction. Service of process must be made in strict compliance with statutory methods. Quote, notice received by means other than those authorized by statute does not bring a defendant within the jurisdiction of the court. End quote. Macchia versus Russo. A defendant's receipt of actual notice of the action, in other words, does not stop him from challenging service that was made in an unauthorized manner. When the requirements for service of process have not been met, it is irrelevant that the defendant may have actually received the documents. Yeah, he can tweet about it all day. It doesn't matter. He still has an argument that service was improper because you left it with a party that has adverse interest to his own, and therefore service is improper. I think that's a pretty compelling argument. Hopefully, Asterios' attorneys look into that, do a little more research, look up the case law, and figure out if that's an appropriate avenue. I don't know. I'm not a New York attorney, but presumably Asterios has a New York attorney who will be looking at this. In any case, him tweeting about it doesn't somehow accelerate the timeline to say that he was served on the 9th. He was not served effectively until December 9th, 10 days after you filed. That's when service is complete. That's when it happened. You're still terrible at this. Whoever's writing these documents, I don't know if it's Maddox or Landau. Landau, if it's you, dude, not okay. Not okay. Not okay at all. Maddox, if it's you, I don't expect you to write anything good anymore anyway. So, anyway, guys, thanks for joining me on this. I find it very funny. I'm gonna try and edit in some documents so that this isn't so confusing to just listen to some dummy ramble on about it. But my editing skills are meager, so we'll see. But cheers. Hope you enjoy this, and I am thoroughly enjoying this Lagavulin. And I will enjoy seeing how the court handles this, because it should be funny. Anyway, peace. Good night.